Hello, everyone, and welcome to today's show. It's a pleasure to welcome my co-host, federal regulations expert and FAR whisperer, the one and only Stephen Koprince. Welcome, Stephen.
Hey, thank you, Carroll. I'm excited to be here and to have this chance to have just a conversation. Usually when I'm with you, I'm sitting there with a slide deck and presenting in a formal manner, and then that's fun too. But it's also nice to have back and forth a discussion about what's happening in federal procurement, starting with our first edition of this GovCon Roundup Live.
Thank you for taking some time out of your busy retirement schedule to do this show with us. We're tremendously grateful to you. For those of you guys who don't know Stephen, he spent his career as the top GovCon attorneys that was focused on small business matters. And before he and I started doing some things together, probably back in 2012, I followed Stephen for a long time to keep myself up to speed with everything. And I'm also glad to see he's continuing to write articles on his GovCon Roundup newsletter, which is why I wanted to create this show with him, because as I would read those, I was like, man, I got some good questions I want to ask Stephen. And so I thought this would be a great forum to ask those questions and also to give you guys an opportunity to ask those questions as well. Let's jump right into today's show, which is going to be based around an article that you wrote on LinkedIn titled "The Pending FAR Overhaul, Some Initial Answers." That was mainly focused on your read of the executive order titled "Restoring Common Sense to Federal Procurement." Not sure if that's possible, but that's the title of that particular executive order. And that was published on whitehouse.gov website on April 15th. And then you released this article on April 16th saying that this is going to be the most significant change to federal procurement regulations in decades. For those who might not have had the liberty of reading your article or the executive order, can you give us a little bit of a recap about what that was and what does that mean essentially in a nutshell for federal contractors? And since you wrote that article, are there any other things that you've seen since then that might be some updates that you want to share with our community today?
Yeah, absolutely. And thank you for that kind introduction, Carol. I always prefer when you do the superlatives for me. That way I come across as being like I got a big head or something. Thank you, everyone, for attending today. It's been about 2 months since I wrote that article. There have been some developments since. So let's talk a little bit about this for those of you who, have businesses to run and aren't sitting there reading the federalacquisition.gov website every day to see what's happening in terms of this FAR overhaul, what's now being called by the administration the revolutionary FAR overhaul, because everything in government contracting has an acronym. It's RFO. So you hear it called FAR 2.0 or you hear it called RFO. It's the same thing. It's this process of overhauling the FAR. The White House published this executive order on April 15th with the confirming rumors that those of us who keep our ear to the ground in the procurement had been hearing for some weeks, that there's going to be an initiative by the administration to overhaul the FAR, to simplify it, bring it back to its statutory roots. It was called Restoring Common Sense to Federal Procurement, and what it does is it directs the Office of Federal Procurement Policy, working with the FAR Council, to dramatically overhaul the FAR. And my article took a look at the key things that the executive order said and what that means for the procurement community. Why are we overhauling the FAR? According to the executive order, conducting business with the federal government is often prohibitively inefficient and costly. The executive order points out that the current FAR is now more than 2,000 pages in its print form, and it's grown and grown over the years. So when I started my career, my law firm bought us the print version of the FAR, and even back then, you could probably get pretty buff by just weightlifting those things if you wanted to, because they're thick, and it was like 8-point font or something. So there's a lot of regulations. They're saying this has gone too far. It's unnecessary bureaucracy. In the administration's eyes, the current form of the FAR, it's just too much. It's a barrier to good procurement rather than a rule book for good procurement, that it prohibits or discourages businesses from entering the market in the first place because they take a look at that rule book and like, ooh, not for me, and can result in ticky-tack violations of rules, things that are discouraging for contractors to maintain themselves in the markets. The administration says we're going to do this. This sounds like the type of process that maybe is going to take decades to complete, because those of you who are familiar with the FAR Council and how it adopts changes to the FAR know that oftentimes that takes a long time. A few years ago, the SBA, Small Business Administration, overhauled its rules on limitations on subcontracting and said, we're going to do a new formula for limitations on subcontracting. The FAR Council then had the job of essentially copying that into the FAR, FAR 52-219-14. That's the clause for limitation on subcontracting in the FAR. It took them 5 years to get that clause. The SBA had already written the rule. They just really needed to copy it in the FAR. So you might say, this is going to take a long time if we're going to overhaul the whole FAR. But the executive order says, it says 180 days. That's what you have, FAR Council. You have 180 days to make this happen. By my count, that's mid-October, about October 13th of this year that the process is supposed to be complete. So then the major question is, we know who's doing this. It's OFPP with the FAR Council. We know the timeline that it's supposed to be done, which is 180 days from the executive order, which is April 15th. So what is going to be in and out of the new FAR? The executive order says that the overhaul of the FAR should contain only provisions that are required by statute or are otherwise necessary to support simplicity and usability, strengthen the efficacy of the procurement system, or protect economic or national security. We're going to categorize what's in the FAR under 3 categories. One that is going to stay, and those things that statute requires. Those are the laws that Congress actually passes. And so it's a bill that's been passed by both houses of Congress, House and Senate, signed into law by the president in most cases. So that's statute. It's a U.S. code, USC, U.S. code. Those are statutory commands. An executive order cannot overturn statute. Executive orders are powerful, but the president cannot, by executive order, create a rule that conflicts with a statutory command. And so clearly this executive order says, look, if statute requires that it be in the FAR, it's going to stay in the FAR. The second category of things that this executive order is looking at are going to be things that could stay in and could go out. And those are things that the FAR Council in its delegated authority has implemented. And so by that, Congress is sometimes very specific about what it wants. It says, hey, FAR Council, write a provision saying that under the simplified acquisition threshold, we're going to apply this rule of 2. And we'll talk a little bit more of rule 2 in a bit. And then the FAR Council does that, writes exactly what Congress said, puts it in the FAR. Sometimes Congress is much more vague. It says, FAR Council, we want you to adopt policies that promote the opportunity for small business to compete in the government marketplace. And the FAR Council goes with the SBA in this case, probably because it's a small business issue, and creates a policy. Those are things that we don't know if they're going to stay, because those are not specific statutory commands. Those are things that the FAR Council has done because it was implementing some of this broader policy goal that Congress created, but it's not required to be in the FAR. So that's where we say it might go, it may stay. And then the third category of things that are in the FAR are items that are in there because of executive orders. The president has authority to repeal any executive order that he issues or that any of his predecessors have issued. And those things are going to stay or go depending on what this administration thinks. If it's based on a previous executive order, the president can, with a stroke of a pen, repeal that. And so that's just in the discretion of the executive, whether to keep or repeal the items that are in the FAR due to executive orders. So that's what we're looking at here. One final piece of the puzzle is the executive order does address FAR supplements. And so those of you who are experienced contractors, I'm sure you've seen DFARS, Defense Federal Acquisition Regulation Supplement. You've maybe seen the VAR, it's the VA version. Most, if not all, of the major procuring agencies have supplements that add to the FAR. So you've got your 2,000 pages, then you've got some supplement on top of it that deals with agency-specific procurement policies and rules. What happens to those FAR supplements? Those are also part of this process. And so the executive order says that each procuring agency that has a FAR supplement is supposed to appoint a representative to meet with OFPP and the FAR Council and work through this process so that the FAR supplements go through the same process as the FAR in terms of being revised and in terms of trying to drill down to those statutory roots and say we're keeping that and then addressing the rest of it. And is this really important to have in the FAR type question? So that's what the executive order says. I'm going to pause there for your questions and comments, Carroll, and then we can talk about where the process has gone in the first 2 months following the executive order.
We're going to circle back to that question because there's been some executive orders that have already been revoked. Those have already created impact. And for those of you who haven't been paying attention, we're going to talk a little bit about that and one specific example and why it's important to stay abreast of these changes. So before we close, we'll talk about that. But outside of that, Stephen, in your opinion, when you're looking at what are these like non-statutory provisions that if removed, or maybe that you're hearing being discussed, if they were removed, would have the most significant adverse impact on small businesses and how?
That's your rule of two. The rule of two is under FAR Part 19.502. That is really the primary vehicle by which the government issues contracts or solicitations as small business set-asides. And what the rule of two says, and I'm just going to oversimplify it here, essentially, is that when, based on market research, the contracting officer has a reasonable expectation that two or more qualified, capable small businesses are likely to submit offers, then the contracting officer must issue that acquisition as a small business set-aside at the offers at fair market prices, must issue the acquisition as a small business set-aside or other small business contract, such as an 8A set-aside or HUBZone set-aside. That is the primary vehicle that the rule of two uses to promote the policy that small businesses be given a fair opportunity to compete and win a fair proportion of federal contracting dollars. When we have multiple small businesses who are likely to bid at fair market prices, they're qualified, capable, let's restrict that contract for a small business. That rule of two, in large part responsible for the fact that every year the government has exceeded its 23% goal for small businesses, 23% or more of contracting dollars being awarded to small businesses. And last year was like 27, 28%. They've been exceeding it by a fair bit. And we can argue about the goaling and whether the numbers are accurate and all this sort of stuff. That's a totally different question. But the bottom line is the rule of two is pushing billions and billions of dollars toward small businesses. The thing about the rule of two is it's only in statute below the simplified acquisition threshold. And so the simplified acquisition threshold, $250,000 for most acquisitions, 15 USC is the part of the federal statute that discusses SBA matters, small business matters, below the simplified acquisition threshold, or actually between the micro purchase and the simplified acquisition thresholds. The rule of two is statutory, it's mandatory. A RFO process cannot remove the rule of two because it falls into that first bucket I talked about where if it's in statute, it's a specific statutory command, it stays in because the FAR Council, OFPP, and the president altogether don't have the authority to overturn statute. However, above the simplified acquisition threshold, which the standard threshold is $250,000, but there are exceptions to that where it's higher, the rule of two is not statutory. It's the FAR Council in its discretion, this has been for decades now, has been on the books, in its discretion, decided to write a rule that's very similar to the statutory command for between the micro purchase and simplified acquisition thresholds in order to promote the broad congressional policy of fair proportion of contract dollars going to small businesses, fair number of contracts, opportunities being offered to small businesses. And above the simplified acquisition threshold, that rule of two falls in the category of we don't know what's going to happen to it. If that goes away, and there's been rumblings that I've heard, this is just rumors that it could, in fact, go away and be turned into, instead of a requirement to do this rule of two, a sort of unenforceable guideline, a buying guide sort of thing. That's just a rumor that I've heard. I can't tell you whether that's true. It's rumors. But that's what I've heard, is that there's a risk that this rule of two could go away, and that is true. There is nothing in the statute that mandates that this stay in the FAR. That could go away. And maybe it just becomes some sort of, contracting officer, if you feel like doing a small business outside, you can, but there's no requirement to do it. And for me, as a small business advocate, because I spent my career working for small businesses for the most part, I have some clients who are large too, large businesses, and other clients of mine who started small and grew large. But I would guess 95% of my clients, at least when we first started working together, were small. I've always been a strong advocate of small business. Our system is designed to do many things, and one of them is to promote a broad industrial base and brings businesses from all walks of life in as federal contractors, and that means small businesses, not some monopoly or oligarchy system where it's only a few large businesses are winning contracts. This could be a major blow for small businesses if this rule of two goes away. This is the government's primary tool for getting that 23% and more to small businesses. Without the rule of two, I would be concerned that small business contracting could fall off the cliff in a pretty big way. Who knows what will happen at this point as we sit here in mid-June, but that is the one that keeps me up at night, worrying. It could stay, it could go, it could be watered down, all sorts of things could happen to the rule of two with this process.
Yeah, the fact is that a lot of those IDIQ type contracts, the 5-year contracting vehicles where they push a lot of work through, would ordinarily fall within that rule of two statutory simplified acquisition threshold. If the actual IDIQ is not put out as a small business set aside, what happens then? Is nothing inside of that subject to the rule of two within the IDIQ?
There are court cases about Rule 2 applying to orders, but if the Rule 2 doesn't exist, then it doesn't matter whether it applies to the IDQ level or the order level, because it's not there. Some contracting officers will, but others will say, and this is not fair. Just small businesses, that's risky. I'm going to go with brand name large business because if they fail, I'm not going to get in trouble. It's like that old adage from back when IBM was the big player in the field, like nobody ever got fired for buying IBM. Whether they're good or not, you're not going to get in trouble if you go that route. And I do worry that some contracting officers, and this is not to pick on contracting officers, but their ultimate goal is to accomplish a task. And this is not to pick on small businesses. I know many of them are not only capable of accomplishing those tasks, but in many cases are capable of doing it better than the largest. But the large business is safe. It's a brand name. The contracting officers does not appear like there's a risk when you hire a large business known household name to do your task. And would hardly blame somebody who says, I'm just going to go the safe route and go with the 2025 equivalent of IBM because nobody ever got fired for buying whatever company that is. So that's the sort of thing the rule protects against. That sort of mindset. Now you've got larges and smalls competing, and smalls will win some of those competitions, but they're also going to lose a lot.
Yeah.
Or they're just going to be discouraged and say, I don't want to enter the market if I got to bid against Google. Why would I do that?
If you were sitting on the FAR Council, or perhaps if there were some people from the FAR Council watching this show live or on demand later, if there's any specific provisions that, if removed, could reduce barriers and maybe help small businesses, do you have any specifics in mind?
That's a good question, and I can't say that I have specific ones in mind right now. I do think that the process as a whole is positive in terms of bringing more entrants to the market. The notion that we want to not only reduce the number of regulations and reduce the size of the rule book, but also write the rules in plainer language, which is something else the executive order has asked for, is helpful. Some of these barriers are potentially statutory in nature in terms of qualifying and all these sorts of things, but I think that the mindset among a lot of the folks in industry, and it's not necessarily wrong, is that government contracting is overregulated, that it's really hard to get into the field because there's so many rules you have to follow, and the rule book is so long that nobody could ever learn all. When you see a FAR rule, you can't understand what it means half the time because it's written in legalese. And there's some truth to that. The whole FAR doesn't apply to any contractor. A lot of it's just internal rules for the government, or it applies to bidding, negotiate procurements. So FAR Part 14, it's a sealed bid, doesn't apply to you. So never been quite maybe as bad as folks say, but there's no question that is true, that it can look very scary to see this laundry list of FAR clauses just incorporated by reference in a contract, and you're supposed to look up 50 different clauses and understand what all of them mean and comply with all. And the answer is, yeah, they're all part of your contract. I do think this process has value. I do think that some of the stuff that is discouraging contractors right now, like CMMC, for example, that's not going away. That's going to stay, but I'm not saying it should go away. Or these new questions about they're strengthening the rules on FOCI, for ownership, control, and influence. I'm not saying that should go away, but that's going to stay. Some of these provisions about Buy American, they're actually strengthening those provisions. Those aren't going away. Those are going to stay. And so I do think that some of the things that contractors find challenging when selling to the government, this process is going to potentially reduce some of that, but it's certainly not going to eliminate it, because a lot of those have statutory roots and they're not going away unless Congress changes its mind and says, sure, you can sell us Chinese products anytime you want. And that's probably not going to happen.
Yeah. It's interesting, Steve, if small businesses are concerned about this, if they don't want to see the rule of two go away, or perhaps maybe some of those Apex Accelerator folks that are out there probably watching this now, or maybe even some of the SBDCs that support some of their clients in government contracting, what can be done to influence or make the case on what should stay or go? And it sounds like the FAR Council has that discretion.
Yeah, for now, they do.
Email to the FAR Council?
You can, actually, yeah. You go to the revolutionary FAR Overhaul, put that into Google or your favorite search engine, and pull up that page. It's part of the acquisition.gov website. There is an email where they say you can make your opinions known. There's no harm in doing that. How much that will be considered as they move forward, I don't know, but certainly putting your 2 cents in and saying the rule of two is how I get my business. If you take this away, you're going to kill my business. If that's true, don't lie and say that's true if it's not. But if that's true, then I'm not going to sell the government anymore if I have to compete against Microsoft, because no thank you. Tell them that. There is a bill introduced in the House of Representatives. I don't remember the day it was introduced, but it's called the Protecting Small Business Competitions Act of 2025. It was introduced by Representative Velasquez of New York. It's H.R. 2804, if you want to know the number of that. Again, I'm not up there lobbying on Capitol Hill, but what that bill would do is codify the rule of two above the simplified acquisition threshold. It would put it in the statute. It would solve the problem. To take it from the second bucket I talked about, which is could stay, could go. Depends on how important we think this is for federal procurement policy, and move it into the first bucket, which is must stay because it's a congressional command. That's what that bill would do. I personally support the bill. This is my personal opinion. It doesn't reflect the opinion of Govology or any of the other entities I work for. I support small business, and I think this is important to safeguard the Rule of Two, which is really important for small businesses. So that bill was introduced. It is now in front of the House Committee on Small Business. If you're someone who would support that bill, take a look at it, reach out to your member of Congress, let them know that you support this bill, especially if your member of Congress is on that House Committee on Small Business. You can go to the committee's website and see who's on that committee. That's the committee that would ultimately decide whether that bill moves forward to the full House floor. So we'll see. That could be passed as a standalone bill. It could be included in a National Defense Authorization Act or some other omnibus bill. The gold standard to protect the Rule of Two would be to put it in statute, because then it's safe unless Congress decides to repeal it. So we'll see if that moves forward. And then finally, the FAR Council has this discretion. Email them. Ultimately, there will be a formal rulemaking process on this through the Administrative Procedure. Now, the FAR Council is going through this RFO process by producing revised versions of the FAR part by part. They're doing revisions. They're posting them on their website and encouraging agencies to adopt them temporarily as deviations. Ultimately, to replace the current FAR with the RFO FAR, they have to go through a formal rulemaking process defined again by the Administrative Procedure Act. And what that's going to involve is the FAR Council is going to have to issue a proposed rule that says we want to replace FAR with the RFO FAR. And at that point, the public has to have the opportunity to weigh in with formal comments on that rule. So that would be another opportunity to weigh in. The problem is that if this Rule of Two goes away in RFO Part 19, by the time we get around to commenting on the draft, it will likely have been out of the FAR deviation-wise, at least, for some period of time, months, maybe years. So it's not a perfect answer, but it is ultimately something you'll have the opportunity to do. All of us will have the opportunity to comment on the Administrative Procedure Act process. My two items that I would leave folks with are write to the FAR Council and the OFPP through that email address on the website, and consider supporting HR 2804, which is that Protecting Small Business Competitions Act of 2025.
Awesome, man. That's a great tip. And I hope that all of you do that and really get your voice heard out there. Thank you for that tip, Stephen. I want to quickly talk about something that you mentioned earlier. Executive orders are made by the president. They're not statutory. We've already seen some executive orders from the Biden administration revoked. One has been related to small disadvantaged business. The goal was set at 15%. Now it's been revoked back to 5%. The other big one that I think is really impactful in terms of price, when people are pricing wage rates in certain contracts, is the one about the federal minimum wages. President Biden had made an executive order to set the federal minimum wage at $15 an hour, which now adjusted for inflation would be like over $17 an hour. That was revoked. You and I were talking about this before the show. Where is it now? You got to go back to what was the last executive order, which was posted by President Obama, which was set, I think, about $10 something an hour, and adjusted for wages, inflation, like 13 something an hour. So it's very confusing to a lot of folks. What is your take on some of this quickly? And are there any other ones that you've seen that kind of have been revoked that really could significantly impact the way a contractor is doing a proposal or pricing?
Yeah, you're absolutely right. At the start of his term, the president revoked a whole bunch of executive orders that his predecessor issued, as well as some executive orders that were issued by previous presidents, many in the Biden administration, but from previous administrations as well. Yeah, I think there are just three. You spoke about two of them. I'll highlight one more. This is why 2025 is going to be one of the most impactful years for federal procurement regulations, as we not only have this RFO process going, but we have also executive orders that are touching this as well. There were a number of executive orders that were repealed. I'll highlight just the three quickly. One was, as you mentioned, the goal for small disadvantaged businesses. That goal is set by statute at 5%. Small disadvantaged businesses is a category that includes 8As, which are essentially certified small disadvantaged businesses, and it includes folks who check the box in SAM to self-certify as small disadvantaged businesses. My opinion is you probably shouldn't do that. You probably shouldn't self-certify as a small disadvantaged business on SAM. Different question, but there's not much advantage to it because there's no set-aside contracts or sole source contracts for self-certified SED. The Biden administration took a look at the numbers and said, we've been beating this 5% goal for years. We're up around 10, 11%. We want to increase the goal for SDB to 15%. So that originally was just kind of an internal policy memo, and President Biden issued an executive order setting the SDB goal at 15%. Remember, I said a president cannot overturn a statute. If the statute set the goal at 5%, how could President Biden increase it to 15%? That's because the statute in question puts 5% as a floor, but allows the president to unilaterally increase any goal. President Biden, to my knowledge, is the only president to ever have done this with any of the goals, but by executive order, using the power delegated by statute, increased the SDB goal to 15%. It was a staggered thing, like 11%, 12%. It's supposed to be 15% this year, 2025. That executive order was repealed. Now, that freaked some folks out. They said, oh, does that mean there's no goal for SDBs anymore? No. That just means that the goal resets to a statutory floor of 5%. The SBA has confirmed that. They issued, not long after this executive order, a goaling sheet essentially saying, yep, the goal is 5% again per statute. So that's one. You highlighted the second one. I think an important one to keep an eye on as well is federal contractor minimum wage. And the federal contractor minimum wage is for folks working on federal government contracts. This is different than our prevailing wage statutes like Davis-Bacon Act, Service Contract Act. Essentially, it's a number above the national minimum wage that we as a government have wanted our folks working on our contracts to be making above the national minimum wage. That's been done by executive order. President Obama issued an executive order during his term that established a minimum wage for federal contractors. President Biden then issued an executive order with a higher number. Both were being adjusted for inflation. President Trump repealed President Biden's executive order, but did not repeal President Obama's executive order. And so what that means is that the Biden higher number disappears and that the minimum wage doesn't revert to the federal national minimum wage, but instead reverts to the Obama minimum wage adjusted for inflation. And so that's where we are, which I think, as you mentioned, Carroll, would be somewhere around $13.30 right now. The added wrinkle to this is that these Obama executive order and the Biden executive order were put into regulation by the Department of Labor. And as far as I know, the Department of Labor has not yet implemented the executive order by repealing in its regulations the Biden number, right? If I'm correct, if they haven't done that yet, we've got this odd situation where you've got a minimum wage that the DOL regulations are going to require, but there's no legal underpinning for it anymore because the legal underpinning was an executive order. Maybe your contract bakes in one number or the other. I don't know. If I were in that boat, because this is not a legal advice show, I would call my attorney and say, here's where I am. I need to know what number applies to me right now on this contract and let them walk through figuring out whether you're under the old Biden number, whether you're under the Obama number, what happens to those employees under the contract that might be affected by this. And then the third thing I'd mention is that President Trump repealed the executive order that inserted an equal opportunity clause into the FAR. The FAR equal opportunity clause had been there for 50 years. It had been there through administrations of both parties. It's the clause that required contractors to adopt certain opportunity requirements. That has been repealed. And so what does that mean? Does that mean you can just randomly discriminate however you want? No. There's still plenty of non-discrimination laws out there like Title VII. There's state non-discrimination laws. So I say there are definitely nuances to that at the contract level, but it does not give you green light to start. Not that anyone on this webinar would do that, but it was just a shock to a lot of folks because this clause had been there for so long in federal contracting to see that disappear. So those are the ones. They're not the only ones. In fact, if you're curious, go again to your favorite search engine and search something like executive orders repealing contractor FAR clauses, and there are some articles out there that will walk through some of the other changes that have happened. It's good just to get that kind of higher level view because most folks running a business don't have the time to be hunting around on the whitehouse.gov to look at the executive orders and compare it to their contracts. But there are a lot of great folks out there, attorneys and consultants and others who are keeping a close eye on this stuff and writing on LinkedIn or on their law firm blogs, articles that can give you a high-level overview about what's going on. And now more than ever, I think it's important for contractors to educate themselves and to find folks that they trust and like, that write in a way or that speak in a way that's understandable to them, that cover these sorts of things so they can stay up to speed on what's going on, because there's just so much. Stuff's flying at you. But there are people out there who their whole job is to keep on top of this stuff and advise people and You can call them and pay money for a consultation. That's wonderful too, but you can also find a lot of great information out there totally free. And that's a great place to start, as long as the source you're getting it from is someone who's trustworthy and knows what they're talking about.
This has been great, Stephen. I want to wrap up here, and we're going to get to some questions from the audience. I've got a couple of announcements and give you guys a couple of plugs. It's so important to really stay abreast of these changes, because you can see just how the revocation of one executive order can put you at a significant disadvantage in some pricing models, pricing $5 off what other people might be pricing per hour. It's just one example. I encourage you to continue to join us every month. We're going to be coming back and talking about more of these topics. We're going to be talking about updates as we see them and as they occur. Stephen writes that on his GovCon Roundup newsletter on LinkedIn. You could actually simply Google, if you just do GovCon Roundup newsletter LinkedIn, it'll bring you right to his newsletter. Highly encourage that you guys subscribe to that. Also, another great resource is the smallgovcon.com blog. It's a blog that Stephen started when he was a federal contracting attorney. It's being continued by the good folks who purchased his law firm, Koprince, Pottroff, and McCall.
These are former partners of mine, friends of mine. They're wonderful human beings who know this stuff really well. So they and their colleagues, attorneys as well, focus exclusively on federal government contracts law, and within that, vast majority of their work is still with small businesses, as it was when I was with the firm.
For those of you who want to join us next month or check out the recording, you can go to govology.com/YouTube. That's going to jump you over to our YouTube page where you can watch the recording. Also, you can go to govology.com/roundup if you want to join us live for our next show, where you can ask questions in the Q&A afterwards. And with that, I'd like to go ahead and sign off from the first part of our show here today. This wraps up the GovCon Roundup Live Episode 1. Thank you so much, Stephen, for being with us. We're going to be back next month with more insights, updates, and real talk from the front lines of federal contracting. Until next time, stay smart, stay informed, and we'll see you then.